Hello and welcome to HIPAA compliance training. This is part 3 of a 3-part series. Today, part 3 will be dealing with understanding Hipaa breaches and HIPAA's enforcement rule. Now I ask that you pay attention, for later on you're actually going to be tested on the materials presented today. And this training seminar program today, it's intended to provide you with a basic and general understanding of Hipaa breaches and HIPAA's enforcement rule. You see, this program is not intended to be an all-encompassing and completely inclusive course on Hipaa breaches, nor the enforcement rule. You should actually regularly review your practice's HIPAA policies and procedures for further comprehension and knowledge of HIPAA. And any questions that you may have regarding HIPAA breaches and/or the HIPAA enforcement rule and/or any other portions of HIPAA for that matter should immediately be brought to the attention of your practice's HIPAA privacy officer and/or HIPAA security officer. And this is not legal advice. The information provided today is strictly for educational purposes only and is not, nor is it intended to be, considered or interpreted in any manner whatsoever as legal advice. This is also not a one-and-done type of compliance program. You see, simply by attending a seminar or watching this video in no manner whatsoever provides a guarantee of compliance with HIPAA. At a minimum, continuous compliance with HIPAA requires an ongoing and active implementation of your practice's HIPAA policies and procedures, as well as current updates, reviews, and maintenance of your policies and procedures, the regular training and testing of your workforce members, the testing of your implemented security and privacy safeguards, and performing an annual risk analysis. So therefore, what I mean is, more work actually still needs to be done. You see, although informative and educational, this training seminar is not intended to replace nor substitute the necessity for ongoing internal HIPAA training and testing of your workforce members, as well as the regular review and updates as needed and necessary of your HIPAA policies and procedures. The continued maintenance of your compliance program is mandatory. And this training seminar, is just one aspect of your overall HIPAA compliance program. Now, SMB Networks provides HIPAA compliance program materials and training seminars to your practice. But please understand that no representative of SMB Networks is acting as the privacy officer and/or security officer or any type of compliance officer for that matter for your practice. It's therefore incumbent upon your practice, as well as mandated by HIPAA, to designate a privacy officer and security officer. And your practice's privacy officer and security officer must familiarize him or herself with HIPAA and all of the required rules and regulations. And there's certainly more than meets the eye today. Now, every effort has been made to facilitate an effective and well-designed HIPAA compliance training seminar program. However, in the interest of time efficiency, some topics, they'll be abbreviated, and others, they just can't be discussed at all. Additionally, there may be some exceptions in the HIPAA rules to the topics that are addressed today. Therefore, any and all questions you have regarding HIPAA should immediately be brought to the attention of your practice's HIPAA privacy officer and/or security officer. Now, before we get started, you might have some questions. The first of which is, why am I even at this HIPAA training seminar program? Well, you're here today because you're a member of this practice's workforce. And according to HIPAA, a workforce member means an employee, a volunteer, a trainee, and any other person whose conduct in the performance of work for a covered entity or business associate is under the direct control of such covered entity or business associate, regardless of and whether or not they are paid by the covered entity or business associate. So the reason that you must attend this HIPAA training seminar program is because HIPAA applies to your employer, and HIPAA requires your employer to provide HIPAA training. But most importantly, as a member of this practice's workforce, HIPAA applies directly to you. Now, regardless of the size of your practice, you must comply with HIPAA. Please remember, HIPAA compliance is not a suggestion. It's a commandment, and mandatory compliance for covered entities and business associates is required. Some important abbreviations for today. CE means covered entity. BA means business associate. BAA means business associate agreement. EPHI means electronic protected health information. IIHI is individually identifiable health information. PHI means protected health information. You may see some of these abbreviations during this seminar program today. Now, HIPAA is the acronym for the Health Insurance Portability and Accountability Act, which was passed by Congress back in 1996. It applies to both covered entities and business associates. It also requires the protection and confidential handling of protected health information to protect the privacy and security of such information. It requires covered entities and business associates to develop, implement, and enforce policies and procedures for the protection of individuals' protected health information. And basically, there are three elements for you to be aware of in HIPAA when it comes to regards to this training seminar program: privacy, security, and enforcement. And since this is part 3 of a 3-part series, HIPAA enforcement will be the focus of this training seminar program. So let's get started with Hipaa breaches and HIPAA's enforcement rule. Any person who believes that a covered entity or business associate is not complying with HIPAA may file a complaint with the Secretary of the Department of Health and Human Services. So again, any person who believes that your practice is not complying with HIPAA may file a complaint against your practice with the Secretary of the Department of Health and Human Services. And what happens once a complaint is filed? Well, the Secretary will investigate a covered entity or business associate following the filing of any complaint when a preliminary review of the facts indicates a possible violation due to willful neglect. And I will discuss willful neglect later on in this program. But please understand, if in fact the facts indicate a possible violation to willful neglect, the Secretary will investigate your practice or a business associate. In the alternative, the Secretary may investigate any other type of complaint filed. An investigation by the Secretary may include a review of the pertinent policies, procedures, or practices of your practice and of the circumstances regarding any alleged violation. In addition to investigations, the Secretary can also conduct compliance reviews to determine whether or not a covered entity or business associate is complying with HIPAA. And regardless if there is an investigation or a review by the Secretary, a covered entity or business associate must cooperate with the Secretary during such investigation or compliance review. And by cooperation, you must provide requested documents, and you must permit access to the premises and any relevant information requested. Now let's take a look at some breaches involving protected health information in violation of HIPAA. According to HIPAA, a breach is the acquisition, access, use, or disclosure of protected health information in a manner not permitted under the HIPAA privacy rule, which compromises the security or privacy of the protected health information. So here's the thing with breaches. Any acquisition, access, use, or disclosure of protected health information in a manner not permitted under the privacy rule is presumed to be a breach unless the covered entity or business associate, as applicable, demonstrates that there's a low probability, and that those two keywords are important, a low probability that the protected health information has been compromised based on a risk assessment of at least the following factors. And before I give you the factors, I just want to show you again this. Let's say that your practice has an acquisition, access, use, or disclosure of protected health information in a manner not permitted under the privacy rule. The Department of Health and Human Services is going to automatically presume that that acquisition, access, use, or disclosure was a breach, unless, of course, your practice can demonstrate that there's a low probability that the protected health information has been compromised based on a risk assessment of the following factors. So let's look at the following factors. There are 4 factors in a breach risk assessment. All 4 factors need to be identified and addressed in a breach risk assessment. The nature and extent of the protected health information involved, including the types of identifiers and the likelihood of re-identification. The second factor is the unauthorized person to whom the protected health information or to whom the disclosure was made. Whether the protected health information was actually acquired or viewed, and the extent to which the risk to the protected health information has been mitigated. So these are the 4 factors that you have to go through. I want you to understand 2 things though. Number 1, your practice may include other factors in addition to the risk assessment. But they must have all these four factors. These four factors cannot be taken out. Also, number two, the other thing I want you to remember is and understand, your practice may elect not to perform a risk assessment and just notify the affected individuals, the Secretary of the Department of Health and Human Services, and depending on the number of individuals of a particular state or jurisdiction, they may have to notify the media. So again, your practice can elect not to go through the breach risk assessment and just go to the notification portion of a breach. But what it cannot do is say, well, we're not going to do the risk assessment. There wasn't a breach. We're not going to worry about it. They cannot do that. And I'm going to go in greater depth and detail into these four factors of the risk assessment. The first factor is the nature and extent of the protected health information involved, including the types of identifiers and the likelihood of re-identification. So what you're looking at here are a couple of different things. Number one, what type of protected health information was involved in the breach, or the incident, if you will? Did the disclosure involve information of a more sensitive nature, such as a person's credit card number, their social security number, or any other information increasing the risk of identity theft or fraud? Did the disclosure involve sensitive clinical information, such as a person's treatment plan, their diagnosis, their medications that they're on, their test results, their medical history? And can this protected health information disclosed be re-identified based on the context and ability to link information with other available information? So basically, can you go out and take information that you see that it's being disclosed to you inadvertently or improperly, and based on any other information you can get in the public, let's say on the internet, can you piece what was sent to you inadvertently and stuff that you can find on the internet to make a positive identification of an individual? That is the nature and extent of the protected health information involved. That's the first factor. Let's look at the second factor. This is the unauthorized person who used the protected health information or to whom the disclosure was made. See, it's very important to consider whether the unauthorized person who received the protected health information has the obligation to protect the privacy and security of the protected health information. For example, if the protected health information is impermissibly disclosed to another entity that is obligated to abide by Hipaa, that is, let's say another federal agency obliged to comply with another privacy, security law, rule, regulation, or in the alternative, if this other entity that you sent it to inadvertently, let's say it was another covered entity or another business associate, there may be a lower probability that protected health information has been compromised, since the recipient of the information, in our case another medical office, another covered entity, another business associate, is also obligated to protect the privacy and security of information in a similar manner as you being the disclosing entity. So for instance, if in fact your practice inadvertently faxes a patient's record to the wrong doctor's office, you know that the unauthorized person who received the protected health information is under the same obligation and duty to protect patients' protected health information. And that's in the realm of this scenario a good thing that it was inadvertently sent to another covered entity, let's say. But let's say that the fax number that you dialed was one number off from the actual physician's office who was supposed to receive it. And instead, that fax number is now the fax number to a restaurant down the street from you, or in another state, wherever. They are obviously not under the duty to protect the privacy and security of the information in a similar manner as you. So now you have a very different scenario. In the one scenario, the unauthorized recipient was a covered entity, and they know what to do. They know not to redisclose this. And the other example, you sent it to a restaurant who does not know any better not to redisclose this information. The outcome could be very different from the two scenarios. And you need to look at the third factor, whether or not the protected health information was actually acquired or viewed. For example, let's use a hypothetical medical group, and they permit certain workforce members to take laptop computers containing thousands of patients' protected health information off-site for the purposes of working at home. And one such laptop containing all this protected health information was stolen from a workforce member's residence during a home invasion. But yet the laptop, fortunately, was later recovered by the local police and returned to the medical group. And upon receiving the laptop, the medical group immediately had a forensic analysis performed on the laptop, which showed that the protected health information on the computer was never accessed, viewed, acquired, transferred, or otherwise compromised. Now, in that example, the medical group could determine that the protected health information was not actually acquired by an unauthorized individual, even though the opportunity existed. And again, I want you to understand something there of the importance of the hypothetical medical group getting the laptop back and having a forensic analysis performed on it to ensure that the protected health information on the computer or the laptop was never accessed, viewed, acquired, or transferred, or otherwise compromised. In that same scenario, what if that laptop was never recovered? In that instance, the medical group could not make the determination that it probably wasn't accessed, viewed, or acquired, just based on the information that we see there. Based on the information that we see in this example, they could not make the assumption that it was not or never actually acquired or viewed. Again, different outcome because of different circumstances and different scenarios. And the extent to which the risk to the protected health information has been mitigated. You see, covered entities and business associates should attempt to mitigate, that is, lessen, the risks to the protected health information following any impermissible use or disclosure, such as obtaining any recipient's satisfactory assurances that the information will not be further used or disclosed. In fact, satisfactory assurances I would get in writing, such as a confidentiality agreement or similar agreement, or it will be destroyed, and should consider the extent and effectiveness of the mitigation when determining the probability that the protected health information has been compromised. And what I mean by that is, let's say, for instance, in our example, we had protected health information faxed over to another doctor's office. And we know that as a covered entity, that doctor's office has to also abide by the Hipaa's rules and regulation for protecting the privacy and security of protected health information for a patient. In that scenario, your office could probably get written assurances from the inadvertent medical practice that received your patient's medical records. And in writing, they would say, this is what happened, this is what we received. We physically destroyed the fax page that came through by putting it through our shredder, which renders it unreadable, indecipherable. You cannot reattach any of the pieces because it's not like it's shredded in strips, but rather it's pulverized, if you will. In that instance, you can get the satisfactory assurances in writing that the information will not again be used or disclosed. When you have information that is protected health information that is inadvertently sent out and never again retrieved, you're not going to be able to get these satisfactory assurances from the receiving parties, because you don't even know who the receiving parties are probably, that the information will not again be accessed, used, redisclosed, anything of that nature. So again, different scenario, different setup of circumstances, different outcomes. And after you perform this risk analysis, or I should say risk assessment, if after you perform this risk assessment of all the four factors, if an evaluation of all these four risk assessment factors fails to demonstrate that there is a low probability that the protected health information has been compromised, then unfortunately a breach has occurred, and breach notification is required. But again, this is going through and documenting in writing each factor of the breach risk assessment. Now please understand, even before you get into the breach risk assessment, HIPAA excludes on three exceptions, if you will, scenarios that are not considered a breach. The first of which is any unintentional, and again it's important to understand this, unintentional acquisition, access, use of protected health information by a workforce member or a person acting under the authority of a covered entity or a business associate, if such acquisition, access, or use was made in good faith and within the scope of authority, and does not result in further use or disclosure in a manner not permitted under the privacy rule. So, for instance, you have a workforce member of your practice, and they unintentionally acquire, access, or use protected health information of a patient, but the unintentional acquisition, access, or use was made in good faith and within the scope of authority, and does not result in further use or disclosure. So you have a workforce member that inadvertently pulls the wrong file. They are told to pull a patient's file. Unbeknownst to them, they grabbed the wrong file, they opened it up, they looked at another patient's protected health information. And it could be another workforce member who was a patient of your practice. It could be their file. But again, it was unintentional, it was accidental. You know, as a workforce member, not to redisclose what you saw, because you did not have the authority to pull that patient's record. You inadvertently pulled that patient's record. And you realize once you were looking at everything, well, something's not adding up. You look at the name, oh, okay, this is the wrong person. Oh, wow, this person happens to work here. Now, the scenario doesn't have to be that the person works there. I'm just showing you the sensitivity of the nature of what you're looking at. Oh, you know what? I work with this person. I didn't know they're suffering from this. Okay, you close it. You put it back. The disclosure that was inadvertent, the access of the protected health information that was inadvertent, does not result in further use or disclosure in a manner not permitted under the privacy rule. In that instance, Hipaa says that is not a breach. Also, let's look at the second example, or the second exclusion. Any inadvertent disclosure by a person who is authorized to access protected health information at a covered entity or a business associate to another person authorized to access protected health information at that same covered entity or that same business associate or organized healthcare arrangement in which the covered entity participates, and the information received as a result of such disclosure is not further used or disclosed in a manner not permitted under the privacy rule. So here you have, in this scenario, two workforce members at your practice, could be you and someone else, both of whom are authorized to access protected health information. You go and pull somebody's file, and this patient's file that you pull, again, inadvertently, you are not wanting to pull this person's file. You inadvertently pull their file and you hand their file off to somebody else because they needed a different person's protected health information. That person opens up the file, looks at it and says, no, I didn't need this person. And they tell you the person's name again. You go, oh, it's a very similar name. It was an invert, and you grabbed it. You weren't looking carefully. You pulled the wrong file. You go, you get the right file, give it to them, you put the wrong file back. If, in fact, that information that you gave that workforce member is not further used or disclosed in a manner not permitted under Hipaa, that is not going to be considered a breach. And finally, the last example that we have is a disclosure of protected health information where a covered entity or a business associate has a good faith to believe that an unauthorized person to whom the disclosure was made would not reasonably have been able to retain such information. So in this instance, let's say you go and give somebody who is leaving the practice, that just received treatment at your practice, medical records, and you think you're handing them their own medical records, but in fact it's another patient that's coming up to check out as well. You're giving them their medical records. But what you do is you hand them the medical records, or you fold them in half so that only, let's say, the back page is showing and it's the back page of the paper is blank, or you hand it to them in a folder. As they're walking out, you realize what you did, and you go and you ask them for that information back. You see that they're still holding it in their hand. Their hand is at their side. They never picked it up. They never viewed it. In that instance, you can reasonably rest assured that the person would not have been able to retain such information that you handed them because they didn't even look at it. Or in the alternative, if they were walking out, they turn around and say, I don't think this is me. I don't know what this is, but this doesn't look like anything that's me. If they come back and they were not able to retain such information because they just did not look like anything, I don't know what this is, but I don't even know, they just don't recognize anything on there. If they would not have been reasonably able to retain such information, it is not a breach according to Hipaa. Now, breach notification is required following the discovery of a breach. And the next slide or two, I'm going to go what a discovery of a breach is pursuant to HIPAA. But please understand that following the discovery of a breach, breach notification is required. It is required to all affected individuals who are involved in the breach, to the department or to the Secretary of the Department of Health and Human Services. And depending on the amount of affected individuals, the media may need to be notified as well. Proof of notification. In the event of a use or disclosure that is in violation of HIPAA's privacy rule, the offending covered entity or business associate shall have the burden of demonstrating that all notifications were made as required, or that the use or disclosure did not constitute a breach. Now, as for notifications, it's still the burden and responsibility of the covered entity for which the protected health information originated from to make all notifications that are required. The covered entity may designate to a business associate that committed the breach to make the notifications, but it's still under the requirements and responsibility of the covered entity to make all the proper and necessary notifications. The burden of demonstrating that all notifications were made or that the use or disclosure did not constitute a breach is something that is made through proper documentation. You can never have, and I stress this all the time, you can never have too much documented information. Especially when the government comes back and wants to find out whether or not you did your breach risk assessment. Because regardless if you're a covered entity or a business associate, you both are required to do a breach risk assessment. And what I mean by both is, while the burden of demonstrating, or I should say the burden of providing all notification rests upon the covered entity, if a business associate has committed a breach, they themselves have to do a breach risk assessment of those following 4 factors that I showed you previously to demonstrate whether or not the disclosure of protected health information or the use or what have you of protected health information was or was not a breach pursuant to HIPAA. So again, everything has to be documented. Now, a breach is treated as discovered by a covered entity or a business associate on the first day that the breach was known to the covered entity or the business associate, or by exercising reasonable diligence would have been known to the covered entity or business associate. See, a covered entity or a business associate shall be deemed to have knowledge of a breach if such breach is known or by exercising reasonable diligence would have been known to any person other than the person committing the breach who is a workforce member or agent of the covered entity or business associate. And this is important for purposes of notification to individuals, to the Secretary of the Department of Health and Human Services, and quite possibly the media. For there's a time period after the discovery of a breach that notification must be given. So a breach is not necessarily discovered when in fact it's reported to a covered entity or business associate, but rather if in fact by exercising reasonable diligence that covered entity or business associate would have known of the breach, then in fact that day back in time is actually when the breach is discovered and not necessarily when it was reported. Of course, a breach can be discovered on which such date that the breach was known to the covered entity, but again, if by exercising reasonable diligence that breach would have been known to the covered entity or business associate, that's when the government is going to put that breach being as discovered, and that's when the time period is going to start for notification purposes. And it's very important for you as a workforce member of this practice to immediately notify your practice's HIPAA privacy officer and or security officer of any actual or potential breaches. Now, when it comes to talking about breaches of protected health information, what we are really talking about is the breach of unsecured protected health information. Unsecured protected health information is protected health information that is not rendered unusable, unreadable, or indecipherable to unauthorized persons through the use of a technology or methodology specified by the Secretary of the Department of Health and Human Services in the guidance issued under the public law that you see there. You see, if protected health information is encrypted, and usually we're talking about the encryption of electronic protected health information, but if the protected health information is encrypted pursuant to the above stated guidance, then no breach notification is required following an impermissible use or disclosure of protected health information. So for instance, if you have an electronic device that has electronic protected health information stored upon it, but that device is encrypted, then no breach notification is required if in fact that device should become lost, stolen, or compromised by somebody, because the fact that it was encrypted, and so long as the encryption is active and operating. Now, when it comes to protected health information of paper form, somebody's records, files, if you were to have those files stolen, they really can't be encrypted, can they? So the encryption doesn't really pertain at all to protected health information in paper form, but rather just electronic form. You see, and the encryption of protected health information is something known as the safe harbor provision. And the Department of Health and Human Services actually encourages covered entities and business associates to take advantage of the safe harbor provision of the breach notification rule by encrypting limited data sets and other protected health information pursuant to guidance specifying the technologies and methodologies that rendered protected health information unusable, unreadable, or indecipherable to unauthorized individuals. So simply by encrypting and making sure that the encryption device or software or program, whatever, is actually operating in use, if in fact that device that stores electronic protected health information is encrypted, the need for reporting any sort of breach becomes non-existent because of the safe harbor provision. And I want you to understand something about sanctions against workforce members. You see, pursuant to Hipaa, your practice must apply appropriate sanctions against workforce members who fail to comply with its Hipaa policies and procedures, which could be sanctions such as a written warning or, in some circumstances, the termination of your employment for this practice. Now let's look at the enforcement rule. Hipaa's enforcement rules has monetary penalties against covered entities and business associates that fail to adhere and comply with Hipaa. And subject to certain affirmative defenses, the Secretary will impose a civil money penalty upon a covered entity or business associate if in fact the Secretary determines that the covered entity or business associate has violated an administrative simplification provision in Hipaa. And the amount of civil money penalties will vary. And I'm going to show you a couple of scenarios that will go through whether or not the amount will or will not increase. So for instance, if you have a violation and you as a covered entity or business associate did not know of the violation, and even by exercising reasonable diligence would not have known of the violation, the government will step in and administer a penalty, monetary penalty against your practice, starting at $100 and going up to $50,000 for each violation. And the maximum penalty for each identical violation per year is limited to $1.5 million. Now again, you can have 4 different violations. They're not identical. Each one can hold a maximum penalty per year of $1.5 million. Now, like I said before, if the covered entity or business associate did not know of a violation, exercising reasonable diligence would not have known of the violation, this is the penalty that would occur. And reasonable diligence means the business care and prudence expected from a person seeking to satisfy a legal requirement under similar circumstances. Now, if you have a violation due to reasonable cause, and by reasonable cause I mean an act or admission in which a covered entity or business associate knew or by exercising reasonable diligence would have known that the act or admission violated an administrative simplification provision, but which the covered entity or business associate did not act with willful neglect, and I'm going to go over willful neglect next, the penalty starting is $1,000 and it can go up to $50,000 for each violation, and the max penalty for identical violations each year is $1.5 million. Now let's look at violations due to willful neglect. Willful neglect, first of all, means the conscious, intentional failure or reckless indifference to the obligation to comply with the administrative simplification provision violated. Essentially, your practice is thumbing their nose at the government. They know what they shouldn't be doing. They know what they should be doing. They fail to do what they should be doing, and they fail to stop doing something they should do, or they fail to enact something that would have prevented the occurrence of the violation. Now, let's say there's a willful neglect violation, but it's corrected within 30 days of discovery of the violation. As you saw before, what is discovery? In this instance, the penalty for each violation is going to start at $10,000 and go up to $50,000. And once again, the maximum penalty for each identical violation per year is $1.5 million. But let's say you have willful neglect and it's not corrected within 30 days of the discovery of the violation. Well, in that instance, the penalty for the violation is going to start at $50,000, and it can go up to $1.5 million again for each identical violation per year. And as I stated before, the 30-day period for willful neglect begins on the first date the covered entity or business associate who is liable for the penalty knew or by exercising reasonable diligence would have known that the violation occurred. And this again is for willful neglect, and it is not corrected within 30 days of discovery of the violation. In some instances as well, in addition to these monetary penalties for Hipaa violation, there is the possibility for your incarceration. And I don't think I can stress this enough. Please always, always document everything that you do in regards to Hipaa. Regardless if you're handling a breach or responding to an investigation, it is of dire, and I mean dire importance, to continuously document every action that is taken, every information that is reviewed, any conversations with all individuals, etc. In my opinion, it's just impossible to document too much information. You can never have too much information at your fingertips in these scenarios. And please, make a detailed and precise paper trail of everything that occurred from the moment you became aware of the breach incident. Always, always, always document. It doesn't even just have to be breaches. It can be whatever your practice is doing in regards to Hipaa. But whatever it does, write it down. And it doesn't just have to be paper form. You can document electronically as well. So you may want to conserve paper. You may be of the type that doesn't like to document online, or I should say in the computer, but rather you like to write everything down on paper. That's fine. Keep it and store it. And regardless of the size of your practice, the importance of an effective Hipaa compliance program is simply just too great to ignore. Well, that's all I have for part 3. I want to thank you very much for paying attention during the seminar. This part of the seminar program is complete. You may now stop this program video and you can take the exam.